Law of Torts. Introduction. Law is a bundle of rules which regulates the external behavior of individuals in society. The law of torts is the branch of law controlling the behavior of people in society. It is a growing branch of law, and its main object is to define individual rights and duties in the light of prevalent standards of reasonable conduct and public convenience. It provides pecuniary remedy for violation against the right of individuals. The entire law of torts is founded and structured on the principle that no one has a right to injure another intentionally or even innocently. Meaning. The word tort is derived from the Latin term tortum, which means to twist or a deviation from straight or right conduct, and includes that conduct which is not straight or lawful. Definitions. Tort is defined by various jurists as under. A tort is a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively the breach of a contract, or the breach of a trust, or the breach of other merely equitable obligations. Salmond. A tort is an infringement of a right in rem of a private individual, giving a right of compensation at the suit of the injured party. Fraser. Tortious liability arises from the breach of duty primarily fixed by law. This duty is towards persons generally, and its breach is redressable by an action for unliquidated damages. Winfield. In tort, intention is important but not in all cases. For example, in cases of negligence, whereas in crime, intention is the crux of the offense. Despite these differences, the injunction may be granted in tort as well as in crime. There are various wrongs which fall under the law of torts as well as under criminal law. For example, assault, defamation, negligence, nuisance, and conspiracy. Distinction between tort and breach of trust. First, on the basis of damages. Damages in a tort are unliquidated, whereas damages in breach of trust are liquidated. Second, on the basis of origin. Law of torts has its origin as part of common law, whereas breach of trust could be redressed in the court of chancery. Third, on the basis of law of property. Law of tort is not regarded as a division of the law of property, whereas law of trust can be and is regarded as a division of the law of property. Distinction between tort and quasi-contract. When a person gains some advantage or benefit to which some other person was entitled to, or by such advantage another person suffers an undue loss, the law may compel the former to compensate the latter in respect of advantage so gained, even though there is no such contract. The law of quasi-contracts covers such obligations. Wrongful act or omission. The first essential ingredient in constituting a tort is that a person must have committed a wrongful act or omission, that is, he must have done some act which he was not expected to do, or he must have omitted to do something which he was supposed to do. There must have been breach of duty which has been fixed by law itself. If a person does not observe that duty like a reasonable and prudent person or breaks it intentionally, he is deemed to have committed a wrongful act. In order to make a person liable for a tort, he must have done some legal wrong, that is, violates the legal right of another person, for example, violation of right to property, right of bodily safety, right of good reputation. A wrongful act may be a positive act or an omission which can be committed by a person either negligently or intentionally, or even by committing a breach of strict duty, for example, driving a vehicle at an excessive speed. The wrongful act or a wrongful omission must be one recognized by law. If there is a mere moral or social wrong, there cannot be a liability for the same. For example, if somebody fails to help a starving man or save a drowning child. But, where legal duty to perform is involved and the same is not performed, it would amount to wrongful act. Legal damage. The second important ingredient in constituting a tort is legal damage. In order to prove an action for tort, the plaintiff has to prove that there was a wrongful act, an act or omission which caused breach of a legal duty or the violation of a legal right vested in the plaintiff. So, there must be violation of a legal right of a person, and if it is not, there can be no action under law of torts. If there has been violation of a legal right, the same is actionable whether the plaintiff has suffered any loss or not. This is expressed by the maxim, Injuria sine damnum. Injuria refers to infringement of a legal right, and the term damnum means substantial harm, loss, or damage. The term sine means without. However, if there is no violation of a legal right, no action can lie in a court despite the loss, harm, or damage to the plaintiff caused by the defendant. This is expressed by the maxim damnum sine injuria. The detailed discussion of these two maxims is as follows: Injuria sine damno, and damnum sine injuria. Injuria sine damno. This maxim means infringement or violation of a legal private right of a person even if there is no actual loss or damage. In such a case, the person whose right is infringed has a good cause of action. It is not necessary for him to prove any special damage. The infringement of private right is actionable per se. What is required to show is the violation of a right, in which case the law will presume damage. Thus, in cases of assault, battery, false imprisonment, libel, etc., the mere wrongful act is actionable without proof of special damage. The court is bound to award to the plaintiff at least nominal damages if no actual damage is proved. Thus, this maxim provides for 1. Infringement of a legal right of a person. 2. No actual loss or damage is required to prove. 3. Infringement of a private right is actionable per se. Damnum sine injuria. Damnum sine injuria means an actual and substantial loss without infringement of any legal right. In such a case no action lies. There are many harms of which loss takes no account, and mere loss of money's worth does not by itself constitute a legal damage. Case law. In Municipal Corporation of Delhi v. Subhagwanti, where the municipal corporation, having control of a clock tower in the heart of the city, does not keep it in proper repairs, and the falling of the same results in the death of number of persons, the corporation would be liable for its omission to take care. Similarly, failure to provide a safe system would also amount to omission, held in General Cleaning Corporation Limited v. Christmas. The essential requirement is the violation of a legal right. There are many forms of harm of which the law takes no account. 1. Loss inflicted on individual traders by competition in trade. 2. Where the damage is done by a man acting under necessity to prevent a greater evil. 3. Damage caused by defamatory statements made on a privileged occasion. 4. Where the harm is too trivial, too indefinite, or too difficult of proof. 5. Where the harm done may be of such a nature that a criminal prosecution is more appropriate, for example, in case of public nuisance or causing of death. 6. There is no right of action for damages for contempt of court. Distinction between injuria sine damno and damnum sine injuria. First, on the basis of meaning. Injuria sine damnum means violation of a legal right without actual loss or damages, whereas damnum sine injuria means actual or substantial damages without infringement of a legal right. Second, on the basis of action. Injuria sine damnum is always actionable, whereas damnum sine injuria is never actionable. Third, on the basis of nature of wrong. Injuria sine damnum contemplates legal wrongs where there is a remedy, whereas damnum sine injuria contemplates only moral wrongs without any remedy. Negligence. In case of negligence, there is neither foresight nor desire of the consequences of one's own natural acts. However, there is failure to take adequate care as demanded by the circumstances in which the act is done. Negligence is the breach of a duty caused by the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or by doing something which a prudent and reasonable man would not do, whereby damage has resulted to a person. Motive. Motive is defined as ulterior intention. If we say that A has intentionally shot at and killed B, the next question would be why did A intend to kill B? In other words, what was the reason behind A's intention to kill B? It may be because was the legal heir of B and wanted to inherit the property quickly by killing B. Or, it may be that A had some enmity against B and due to that hatred he killed B. Or, maybe A wanted to take some revenge against B. Such intention to acquire B's property through inheritance, enmity or hatred, or intention to take revenge are said to be the motive behind the killing of B by A. Motive is almost always irrelevant in the English law of tort. A man's reasons for doing an act does not make a lawful act unlawful, nor vice versa. Malice. Malice is a term with many meanings. Firstly, it is often used to mean spitefully or with ill will. Like other motives, malice in this sense is invariably irrelevant in law of torts, and therefore, is not essential to the maintenance of an action for tort. Malice in fact and malice in law. It is of two kinds, malice in fact, or express malice or actual malice, and malice in law, or implied malice. The first is what is called malice in common acceptance, and means ill will against a person. The second means a wrongful act done intentionally without just cause or excuse where a man has a right to do an act. It is not possible to make his exercise of such right actionable by alleging or proving that his motive in the exercise was spite or malice in the popular sense. An act not otherwise unlawful cannot generally be made actionable by an averment that it was done with evil motive. A malicious motive per se does not amount to an injury or legal wrong. A defense is a ground on which the defendant seeks to avoid or reduce his liability. Defenses in cases of torts may be 1. General defenses, or 2. Special defenses. General defenses are those defenses which do not depend upon the nature of tort. They are available in all types of torts. Special defenses are those defenses which depend upon the nature of the tort. They are available for that tort only. These general exceptions, or conditions, or justification of torts are 1. Valenti non fit injuria, 2. Act of God, 3. Inevitable accident, 4. Necessity, 5. Private defense, 6. Acts causing slight harm, 7. Statutory authority, 8. Plaintiff the wrongdoer, 9. Judicial or quasi-judicial acts, 10. Parental and quasi-parental acts. Vicarious liability. As a general rule, a man is liable only for his own act, but there are certain circumstances in which a person is liable for the wrong committed by others. This is called vicarious liability, that is, liability incurred for another. The most common instance is the liability of the master for the wrong committed by his servants. In these cases liability is joint as well as several. The plaintiff can sue the actual wrongdoer himself, be he a servant or agent, as well as his principal. In the words of Salmond, in general a person is responsible only for his own acts, but there are exceptional cases in which the law imposes on him vicarious responsibility for the acts of another, however, blameless himself. Modes of vicarious liability. The liability for others' wrongful acts or omissions may arise in one of the following three ways. A. Liability by ratification, where the defendant has authorized or ratified the particular wrongful act or omission. B. Liability arising out of special relationship, where the defendant stands to the wrongdoer in a relation which makes the former answerable for wrongs committed by the other, though not specifically authorized. This is the most important form of liability. Liability arising out of master and servant. In order that the master may be held liable for the tort of his servant following conditions should be fulfilled. 1. Tort is committed by the servant, and 2. The servant committed the tort while acting in the course of employment of his master. The slide covers some of the important topics of law of torts introduction.